Well, welcome back, everyone. Welcome back to Chicago Kent Law Review's Law and Religion Symposium, in search of common ground, religion, and secularism in a liberal democratic society. So my name is Lucien Ferguson. I'm currently the Drinan Visiting Assistant Professor at Boston College Law School. I'll be joining Chicago Kent College of Law as a faculty beginning this summer. And it's my pleasure to introduce you all to the second panel of the day, Church and State. So I want to begin by just giving another round of thanks to those in attendance, to our panelists today, our esteemed panelists, and to the Law Review for organizing this fantastic event. And so I'll just begin by introducing everyone, and then we will get right to the talks and the papers. So Professor Angela Carmella is Professor of Law at Seton Hall University School of Law, and also the James B. and Anita L. Ventantonio Board of Visitors Research Scholar. She's a widely published expert working at the intersection of law and religion, especially on questions concerning the religion clauses of the First Amendment, Catholic social thought, and connections among property, zoning laws, Christianity, and race. And her paper today will be Catholic Institutions and the Religion Clauses, Faith in a Liberal Democracy. After Professor Carmella, we'll be hearing from Professor Richard W. Garnett, who is the Paul J. Scherl Fort Howard Corporation Professor of Law at Notre Dame University, where he also serves concurrently as a professor of political science and director of their program on church, state, and society. He's a leading authority on questions and debates regarding religious freedom and church and state relations. And his paper is entitled The American Model of Church and State, Differentiation, Cooperation, and Healthy Secularity. And then finally, we'll be hearing from Professors Ira C. Lupu and Robert W. Tuttle. Professor Lupu is the F. L. Wood and Eleanor Davis Professor Emeritus of Law at George Washington University Law School and a nationally recognized expert on the religion clauses of the First Amendment. Professor Tuttle is the David R. and Sherry Kirshner Burrs Research Professor of Law and Religion, also at George Washington University, where he is also a professor of religion by courtesy. And he's the author of numerous articles and reports in the field of church, state, law, and legal ethics, and also co-author, along with Professor Lupu, of the book Secular Government, Religious People. Their paper is entitled The 10 Commandments in Louisiana Public Schools, a study in the survival of Establishment Clause norms. So each of our panelists will speak for 15 minutes, and we'll use the remainder of our time to open a discussion. And so without further ado, I'd like to ask Professor Carmella to get us started. Thank you so much, Professor Carmella.
Great, my pleasure. Thank you. I want to thank Steve and Kathleen in particular for organizing this wonderful conference. My paper is a little unusual, a little different from what we heard in our first panel. I think of it as a long letter, maybe too long, to the U.S. Catholic bishops. My point is to remind them of the great blessings of a pluralistic liberal democracy and to caution them to be on the lookout for some newer illiberal movements, Catholic movements, that voice some widely shared critiques of liberalism, but that are, in my view, harmful to both church and state and a bit alarming. Post-liberal Catholics and Catholic integralists both seek the vigorous overthrow of liberalism so that a strong government can remake society, one that is less committed to individualism and more cohesive and communitarian. What could possibly go wrong? Well, the bishops indicated last November an interest in getting to know J.D. Vance. He's a convert to Catholicism and has been quite vocal about his faith journey. Well, they've gotten to know him quite well in the last couple of weeks. Vance describes himself as a post-liberal Catholic. He has maligned the bishops as being concerned more with the money, the bottom line, on federal contracts than with helping the migrants that their entities serve. Then he pointed to Aquinas's theology to support the Trump administration's mass deportations. the very next day, Pope Francis corrected his theology in a letter that the Pope sent to the U.S. bishops. 2 days ago, the U.S. Catholic Conference of Bishops sued the Trump administration over its sudden end to funding for resettlement of thousands of refugees and violating its legal commitments to church entities. Migrants and refugees worldwide, because of their vulnerability, have been a particularly significant group for Francis. So what's going on here? The vice president's low regard for the church's activism goes to the heart of my paper topic. For illiberal movements, operating in the regular framework of liberal democracy will never provide true religious freedom. The government needs to take the reins to promote the common good. We can see this in the talk about pronatalist policies, heightened national fervor, ridding universities of progressives. Hungary is a model. Germany and the EU are failures. A more extreme is an intellectual movement known as Catholic integralism. It's a big tent with a range of proposals, but generally speaking, integralists seek a society more like 19th century Europe, where the ideal was a Catholic confessional state, one that provided for the care of religion by punishing heresy and apostasy and suppressing false doctrines of non-Catholics, because after all, error has no rights. The state thereby orients the population toward eternity, heaven. Authentic religious freedom is freedom for truth. Of course, the reality is that the Catholic bishops of the world did away with that church-state relationship in the 1960s at the Second Vatican Council. After living through the scourge of totalitarian dictators in the first half of the 20th century, they decided that the church had to be open to the modern world, to embrace liberal democracy, that it had to accept the proper autonomy and secularity of the state and the pluralism of societies. The Vatican II Declaration on Religious Freedom rejected the ideal of a confessional state. It was viewed as an historically contingent reaction to the French Revolution. The declaration announced the authentic teaching, a universal right to free exercise of religion that is grounded in the dignity of the human person. No one can be forced to act in a manner contrary to conscience, nor, on the other hand, can they be restrained from acting in accordance with conscience. All people have the obligation to search for truth, but only in conditions of freedom, without compulsion or restraint. Now, the Declaration offers a capacious description of religious exercise. All religious beliefs, practices, both individual and institutional, also communal, of course, within public limits. Churches enjoy a long list of autonomy protections and the right to share their teachings in the political arena. Parents have the right to transmit faith and to select religious schools for their children with the assistance of the state. So the church asks for freedom, and that is precisely what it has gotten in our liberal democracy in this country. 72 million followers, 17,000 parishes, 200 dioceses, thousands of houses of worship, 6,000 schools, educating 1.7 million children, employing 140,000 teachers, 230 colleges and universities, 645 hospitals serving 1 in 6 patients, 4 of the 10 largest healthcare networks, and charitable programs serving millions of people every year, often in partnership with the government, or at least until a few weeks ago. The level of legal protection for this gigantic enterprise is impressive. The American church enjoys every one of the rights set out in the Declaration of Religious Freedom. First, it enjoys autonomy in the management and governance of its institutions and programs, especially in connection with employing teachers in their schools under a robust ministerial exception under Hosanna Tabor and Our Lady of Guadalupe. Second, the exemption jurisprudence under the Free Exercise Clause has grown increasingly robust as was mentioned in the first panel, as we see in Fulton and Brooklyn dioceses. Third, parents now have access to aid programs available to private secular schools, since the Supreme Court held in Espinoza and Carson that religious schools cannot be excluded. 2 of the 3 free exercise cases currently at the Supreme Court this term involve Catholic entities. Liberalism, therefore, in my view, created conditions for this freedom. It has also created, it's gone beyond that, and it's also allowed the church, through its engagement with the liberal tradition, to actually deepen the church's understanding of what's required to uphold human dignity. In particular, the human rights, the development of human rights through the liberal tradition. Of course, I have to admit that even with a substantial reconciliation of the church with liberalism, it's not a perfect fit. Conflicts with liberalism occur when policies and laws regard the human person as predominantly an unencumbered self, holding rights, with duties based only on consent. It is tough to mesh this with the church's teachings on an objective moral order, natural law, transcendent dimension of the human person, and a comprehensive vision of the common good. But the church has decided that advocacy and litigation and its charitable service are part of the kinds of public witness possible in our intensely pluralistic society. They work within the framework of liberal democracy. Now, I think it's significant to remind ourselves that liberalism is neither built for nor capable of providing ultimate meaning in the lives of its citizens. Other institutions are tasked with that endeavor. And law is limited. It does not maintain the spiritual integrity of the person, but rather it allows the peaceful coexistence of all of us on principles of justice. It has been said that liberal democracy creates citizens, not saints. And here is where integralism differs. An integralist regime strives to create saints. These folks seek to sacralize culture by political and legal means and offer a new, actually old, vision for state and society. Have a strong executive, elevate the status of the church, and deputize the state to use civil law to enforce its teaching. Government must act as a caretaker of religion for the spiritual benefit of the citizens. Subordinate the temporal power to the church. But of course, we know that subordination won't really happen. The temporal power will use the church. It will be in the business of blessing the decisions of the state, like when Thomas Aquinas' teachings support mass deportations. Now, Adrian Vermeule, who is best known for his common good constitutionalism, is an administrative law professor at Harvard Law School and is the intellectual powerhouse behind integralism. He thinks the takeover should be gradual, with Catholics entering government in important roles. This has been described by critics as capturing the state ahead of creating and in order to create a Catholic society. And footnote, Vermeule is also a major proponent of the unitary executive, the strong ruler. In an integralist regime, we, the subjects of that ruler, will grow to appreciate the new regime, coming to see the wisdom of its decisions. Now, my suggestion for strengthening liberal democracy, at least from the Supreme Court's perspective, is to ensure that the Establishment Clause jurisprudence serves as some kind of limit to the Free Exercise Clause. The court, I don't think, should fall into an analysis of the history surrounding the founding as the ultimate analysis for what is a violation of the clause. While the historical record can be a very important interpretive aid, originalism can be appropriated for use by illiberal efforts. It elevates a historical era when religious minorities were not full citizens it thereby creates an opening to enshrine particular readings of the Bible, to create a faithful citizenry. Indeed, some of the more extreme integralists talk about limiting public office to Catholics, and then non-Catholics being limited to voting for their representatives, representatives of their faith. So in addition to the historical record, I would suggest additional considerations. First, upholding the principle of secularity of law and government. Although Lemon has been declared abandoned, it seems clear, as Chip Lupu and Bob Tuttle are going to talk about later in this program, that the individual prongs of the Lemon test, like secular purpose, remain viable. Second, upholding the principle of religious equality. As Justice Kagan explained in her dissent in Town of Greece, pluralism and inclusion in a town hall can satisfy the constitutional requirement of neutrality. Such a forum need not be a religion-free zone. She went on to say that the court has to ensure the First Amendment's promise that every citizen, irrespective of her religion, owns an equal share in her government. Third and final, I would suggest curtailing protections for religious monopolies on services and healthcare to ensure that there are a variety of options for the public. So I'm going to stop there. I'm not sure how I was doing on time. I think I'm good. And so I look forward to your comments and questions as we proceed. Thank you.
And thank you so much, Professor Carmella. Professor Garnett, the floor is yours.
Great, thank you. Thanks very much for including me in this event. It's wonderful to be with old friends and people from whom I've learned so much. I should apologize in advance. My remarks in places are going to seem a little bit pedantic or nitpicky. This conference's theme, as we all know, is religion and secularism in a liberal democratic society. And in my remarks, I want to push back just a little bit, gently, I hope, on some of the ways that these words like secularism and secular are used in commentary and public discourse and in decisions about church and state and about religion and public life. Maybe like Inigo Montoya from the classic movie The Princess Bride, I want to suggest that, quote, we keep using that word, but I do not think it means what we think it means. I want to suggest that there's a similar word, but one that's different in interesting ways, a different idea, really, namely secularity. And I'll describe this further as positive and healthy. I think this word actually fits better with the American model of religious freedom, and I think it fits better with our constitutional text and with our tradition and practices. And I think it also fits pretty well with the doctrinal developments we've seen in the Supreme Court. This is an idea that I've learned about from the philosopher Charles Taylor, from Professor Jose Casanova, from the late Pope Benedict XVI, and others. And I should also note, by the way, that for me, a really valuable exploration of what it means for a government to be appropriately secular is a book by my friends and co-panelists, Chip Lupu and Bob Tuttle. I think you heard about it earlier. Secular Government, Religious People. It's a wonderful book. As you'll see, we probably reached some different conclusions about the implications of secularity, but I think their presentation is invaluable. So today, in the time we have, I want to do four things. I want to briefly take stock of the current state and the kind of ongoing development of the Supreme Court's doctrines, interpreting and applying the religion clause or clauses. Second, I want to introduce and flesh out just a little bit this idea of positive or healthy secularity. And I want to suggest anyway that this is an arrangement that's morally attractive in a liberal democracy like ours, unlike integralism, which you just heard about from Angela. And I think this idea of healthy secularity fits well with the court's decisions and doctrines. The third thing I want to do is to just surface 5 themes or features or maybe facets of the American arrangement, that is, of healthy secularity. I'm going to call them differentiation, cooperation, accommodation, recognition, and expression. And yes, I made them rhyme on purpose. Sorry if that was a little heavy-handed, but I think that each of these facets actually helps to explain the American model of church and state. And I think they do a better job than a word that we often hear in the commentary, which is separation, which again is an important idea, but potentially misleading. And then finally, I'll just turn to a few questions about this idea of positive secularity that I think remain to be answered, and that probably will be coming before the courts soon. So starting with the state of things, American church-state scholars disagree about a lot of things, but there's probably a pretty solid consensus that for better or worse, we are living in interesting times. The court in relatively recent years has decided a number of significant law and religion cases. You'll hear about a lot of them today. And I think it's fair to say that it's adjusted and revised its doctrines in several ways from what they were, at least in the latter decades of the 20th century. At least 3 significant cases are on the docket this spring. Some people might start the story of this change in different places. I actually think it started at least 30 years ago in the Rehnquist court, but a lot of discussions tend to focus on the work of the Roberts court. And different commentators might focus on different rulings and different justices, but I want to just highlight quickly 5 developments that we've seen. And again, a lot of my colleagues are going to go into more detail on some of these. The first development is that, as you heard in the previous panel, the court has modified the standard that it announced 35 years ago in Smith, which stated that exemptions from neutral and generally applicable laws are not required, even when they substantially burden sincere religious exercise. In a string of cases, you could say maybe from Lucumi in 1993 through Fulton in 2021, the court really has raised the bar for what counts as a truly neutral and generally applicable state action. And in so doing, it has made it a lot easier for religious claimants to get to strict judicial scrutiny of government actions that interfere with religious practice. The second big development, I think Chip and Bob are going to talk a lot about this, is the abandonment of the so-called endorsement test in the Kennedy case a few years ago. And the announcement that although maybe we didn't notice, the court had long ago abandoned Lemon. I guess that counts as overruling, but the way the court worded it, it just sort of was reported that it had been abandoned long ago. But that's a significant development. The third development that I think is worth surfacing and highlighting is this move to enforce a pretty strict non-discrimination rule in the funding context. So the court has built on cases like Zellman, where it was held that it's permissible for governments to permit religious schools to participate in school choice programs. And as you've heard earlier, in a series of cases, the court has said it's impermissible to discriminate against religious schools in such programs. That's a significant development, I think. The fourth thing to highlight, I think, is the constitutionalization by the Supreme Court of the so-called ministerial exception. That exception had been around for a long time, but the Supreme Court really didn't speak to it until about 13 years ago. And I think this, in addressing the ministerial exception, the court has sort of spoken more explicitly than it had for decades about this principle of church autonomy, the content of which remains to be seen. And then finally, for now, I just think we've seen a number of cases that have continued to provide strong protection for private religious expression, even in public spaces. Now, scholars disagree. Well, some of us on this panel and on the other panels today will disagree about how to characterize these developments. We're law professors, so we think of all kinds of colorful adjectives and epithets, perhaps, to describe the state of the case law. One court called it a hot mess. I'm a little less pessimistic than that. A lot of evaluations tend to involve various descriptions of crumbling walls or lowering walls and so on. Scholars like my friends Micah Schwartzman and Nelson Tebbe have talked about whether these developments signal a kind of privileging of religion or perhaps a reestablishment of religion. But in my view, these developments are positive, and that they're basically consistent with the American model of church and state correctly understood. I've elsewhere characterized these developments as being part of a kind of doctrinal cleanup. One analogy I saw that I liked is the court has pulled up the green shag carpeting that somebody mistakenly put down in the 60s and 70s to to re-expose the nice hardwood below. In any event, you're going to hear more about this today. I want to turn, though, to these terms secular, secularism, and then the term that I want to propose to us, which is secularity. In a lot of American conversations about religious freedom, secular is just used to mean, quote, not religious, or sometimes it's used to mean anti-religious. In other contexts, maybe it means empirical or scientific. So secular means evidence-based, religious means not evidence-based. In the court's doctrine, sometimes we've heard justices get into the question of whether the purpose of government action is appropriately secular. Sometimes in commentary, we hear discussions about whether the arguments that are made in support of a particular policy are appropriately secular or not. There's some interesting cases having to do with church property disputes. I'm thinking of Jones v. Wolf, which I taught just yesterday, where the court seemed to imagine that certain kinds of documents are secular, whereas other ones are not. There's something strange about all this because, of course, as an original matter, the word secular just comes from the Latin seculum, which refers to an age or a generation or a span of time. It really just meant in the world. So for a long time, for centuries, we talked about secular clergy. Those were the priests who worked in dioceses and in parishes and said masses for the people. And they were opposed to the religious clergy who tended to be in monasteries, right, removed from the world. And Charles Taylor, in his recent hugely important book, A Secular Age, reminded us that secular should not be understood in terms of the absence or the erasure of religion from public life. Rather, as he said, what makes our age secular is the fact that religious faith is now seen as one option among many, but it's still present in the world. And of course, religious actors, institutions, and practices are in the world. They are secular. As you heard from Angela, religious hospitals, schools, charities, they're secular in the sense that they engage in the world in a wide range of activities that relate to how we live today, in the here and now. They relate not only to what we believe or to where we will spend eternity. Now, secularism, in my view, is not the best term to describe this enterprise of religious freedom under law in a liberal democracy, with all due respect to the conference organizers. I'm reminded of this classic Christmas movie, The Miracle on 34th Street, when the hero, Kris Kringle, is chatting with a plain-spoken young janitor named Alfred about the threats that are posed to the true Christmas spirit by commercialism. And he says, I won't try to mangle the New York accent, but he says there's a lot of bad isms floating around in the world, and the worst of them is, he said, commercialism. Well, I think secularism also has the potential to be a bad ism. It sounds aggressive. It suggests a program. It sounds more like an ideology or a dogma than a description. It sounds like an effort to bring something about, that is, to bring about the absence or the evacuation of things that are not secular from public life and spaces, from the common life of our political community. As Professor Casanova once put it, secularism is, in his words, a normative ideological state project that sees religion either as an irrational force or as a non-rational form of discourse that should be banished from the public square. Well, if it's understood in this way, then in my view, secularism isn't consistent with the American model of religious freedom, and it really isn't consistent with liberal democracy, correctly understood. Secularity, I think, healthy, positive secularity, has, I think, more promise. It can be seen as a critique, really, of ideological secularism. And for those of you who are interested, I learned a lot about this idea of secularity from Professor Zach Kalo, who's a professor at Touro Law School. He's written a couple papers on this. But also from the late Pope Benedict. In the spring of 2008, he visited the U.S., and he expressed his admiration for what he called America's positive secularity, in which, he said, government respects the role of religious arguments and commitments in the public square, and also the important distinction between religious and political authorities. In a dialogue with Jürgen Habermas in France a few years later, he said it's fundamental to insist on the distinction between the political realm and that of religion in order to preserve both the religious freedom of citizens and the responsibility of the state toward them. In accord with this positive concept of secularity, the law does not exclude religious believers and values from public life in the name of secularism. Instead, it protects everyone against coercion in religious matters, and it leaves to voluntary associations the responsibility of religious education, but it protects and supports their right to carry out this responsibility. So the right to public religion is protected, as is the freedom of private religion, and church and state are separate, not in the sense that faith is excluded from politics, which would be impossible, but in the healthy sense that the institutions of government are separate from and are prevented from interfering with the appropriate independence of the institutions and authorities of religion. So, with that in mind, this sort of image, and I know it's very quick, of secularity as opposed to secularism, let me just turn back to the developments in the court's church-state doctrine in terms of those 5 words I mentioned before. Again, differentiation, cooperation, accommodation, recognition, and expression. This will be too quick in the interest of time, but hopefully you get the idea. The idea of differentiation I borrowed from my colleague Dan Philpott in political science. It just reflects this understanding that religious and political institutions are distinct. They're differentiated. This principle would seem pretty clearly to be related to the idea of healthy secularity. And we can see this principle at work in the court's cases dealing with, for example, the no religious decisions principle or with the ministerial exception. Cooperation is also an important facet of healthy secularity. Religious institutions and actors are different from political institutions and actors, but they can cooperate in pursuit of the common good, in pursuit of, in quotes, secular goods, and there is no wall that prevents such separation. The school voucher cases, I think, are consistent with this facet. Accommodation. It's well established in law now that governments may accommodate religion, including by exempting them. This is a kind of special treatment for religion, but it's a kind of special treatment that I think is consistent with healthy secularity, because a secular government can take account of the fact that people in the world are exercising religion and that they flourish through that exercise. Whether religious believers must be accommodated is a different question, a complicated one. Stephanie Barclay addressed it earlier, as did the rest of the panel. 4th word, recognition. I mean, for this theme, to get to the cases that have to do with things like public symbols, religious symbols rather, in the public space, or statements by public actors, God bless America before the presidential speech. You're going to hear more about the 10 Commandments from Chip and Bob. The court's made it clear in recent years that the no establishment rule does not require the removal of religious symbols and acknowledgments from public spaces. Again, this might seem counterintuitive, but I believe that's consistent with a healthy secularity, because recognitions do not rise to the level of establishments, and it is a fact about the seculum that many members of our political communities are religious believers, and that various religious texts and practices and symbols are long-standing parts of religious public life. And then finally, and I know I'm bumping up against time, expression. By expression, I have in mind the decisions and doctrines that have clearly protected religious expression by private, non-state actors, even when they're in public spaces and contexts. So most recently, we might think of the Kennedy case or the Shurtleff case that was decided by the Supreme Court. As I see it, the public-private distinction is essential to healthy secularity. And there's nothing about secularity correctly understood that requires the government or even permits the government to insist on the complete privatization of such expression. So with that, I had planned to talk about the pending cases this term, but I won't. Maybe we can talk about those in the Q&A. Thank you.
Great, thanks so much. And Professors Tuttle and Lupu, I'll hand it off to you.
Thank you, Luke. And thanks to Angela and to Rick for the plugs for our work. Our paper focuses on the Louisiana law requiring all public school classrooms to display the text of the 10 Commandments. Here is a slide showing one of the 4 versions of the display recommended by the Louisiana Attorney General. A decade ago, no one could foresee the scope of the coming changes in the law of the religion clauses. Nevertheless, the thesis of our paper is that agents of the change, including justices and scholars allied with them have exaggerated its scope. In doing so, they have encouraged other governmental actors to act on unfounded claims about current principles. We can see this in the attempt in Oklahoma to give a public charter to a religious school, in Texas to encourage the use of biblical materials in public schools, and in Louisiana to require displays of the Ten Commandments prominently in every public school classroom. The Ten Commandments dispute, now being litigated in the case of Roque versus Brumley, presents an acute example of this phenomenon. In 1980, the Supreme Court in Stone versus Graham invalidated a highly similar law requiring prominent display of the commandments in every public school classroom in Kentucky. For a majority of the justices, the answer to the Establishment Clause question in Stone seemed obvious. The purpose of the law was to indoctrinate students in the religious message of the Ten Commandments about the identity and authority of God in prescribing norms, some exclusively religious. The opinion cited Lemon v. Kurtzman, but it did not depend on Lemon's three-part test. Stone depended on Establishment Clause first principles that predated Lemon about the impermissibility of state-supported religious indoctrination of children. In 2005, new questions arose in the Supreme Court about state sponsorship of Ten Commandments displays, though not in public schools. One was in a courthouse in McCreary County, Kentucky, and the other was on the grounds of the State House in Texas. The short version of this story is that the court struck down the courthouse display and upheld the one in Texas. In the Texas case, Chief Justice Rehnquist's plurality opinion sharply distinguished Stone versus Graham on the grounds that state-sponsored religious messages in public schools present issues of special constitutional sensitivity. The court had recognized that from the late 1940s all the way through decisions about state-sponsored prayer at graduations and high school football games. In 2005, without question, Stone v. Graham remained good law. Has anything changed that would lead today to a different outcome in the challenge to the Louisiana law? The state has been arguing that the Supreme Court has altered the law in ways that erase the holding of Stone v. Graham and its underlying principles. The state's lawyers pay relatively little attention to the flimsy context statements on the posters about the place of the Ten Commandments in American political life. Instead, they relied primarily on the court's opinion in 2022 in Kennedy versus Bremerton School District, a case involving a football coach in a public high school. The coach had a practice of praying in proximity to the players he coached. The school district had ordered him to stop, and he responded with a lawsuit insisting that his rights to free speech and free exercise of religion entitled him to utter those prayers on school grounds and within earshot of his players. In an opinion by Justice Gorsuch, the court upheld Kennedy's free exercise and free speech claims. It concluded that his prayers were uttered in his private capacity rather than in his role as an agent of the state. There are reasons to doubt that conclusion, but by itself, that did not disturb the validity of the school prayer cases or Stone v. Graham, which involved state-sponsored speech. But Justice Gorsuch went out of his way to cast doubt on the past 75 years of Establishment Clause adjudication. His opinion claims that the court had previously abandoned the three-part test of Lemon v. Kurtzman, concerned with secularity of purpose, primary religious effects, and church-state entanglement, and had replaced those criteria with a quest for historical understandings about what constitutes an establishment of religion. And this assertion has now been embraced by the Louisiana officials sued in the Ten Commandments case. They claim that Stone v. Graham has been erased because it depends on a requirement of secular purpose, which Louisiana argues is no longer operative. Instead, the state says, the prohibition of the Establishment Clause are limited to a discrete list of practices associated with Anglican and a few colonial establishments of religion. They assert that the clause no longer means that the government must leave the teaching of religious truth to the people. In this paper, we argue that these claims of radical legal change are highly overstated. Look closely at the decisions on which Justice Gorsuch relies. He claims that the court has repudiated the Lemon Test in Town of Greece v. Galloway, involving official prayer to open town council meetings, and in American Legion versus American Humanist Association, involving county sponsorship of a Latin cross as a war memorial for locals who died in World War I. The assertion that the norms embraced in Lemon have vanished is neither honest nor accurate. When one reads Town of Greece, American Legion, and Kennedy with care, one sees that the court has been specifically addressing only the endorsement gloss on the Lemon Test. This approach, pioneered by Justice O'Connor, has been controversial for many years. It focused on whether reasonable people would perceive a government practice as an endorsement of a sectarian belief about religion. In Kennedy itself, the court rejects the district's concern that reasonable people would wrongly attribute the coach's prayer to the government. The opinion in Town of Greece, building on Marsh versus Chambers, is primarily concerned with the long-standing and continuous character of legislative prayer. The practice has an originalist pedigree, the court suggests. Written by Justice Kennedy, the author of the opinion in the graduation prayer case, Town of Greece is not a repudiation of anything. In the American Legion decision, Justice Alito's plurality opinion offers arguments that the Latin cross has acquired secular meaning as a war memorial over the past 100 years. This is an attempt to filter public perceptions of a government message through a new and rosier lens. Moreover, Justice Alito explains that courts should presume the constitutionality of long-standing expressive practices addressed by the state to the general public. In a significant footnote, Alito indicates that the same presumption does not apply to cases about state-sponsored religious practices in public schools involving captive audiences of impressionable young people. In addition, the third prong of the test, involving excessive entanglement between religion and the state, has been recently cited with approval by a number of conservative justices, Gorsuch included. The ministerial exception cases are a prime example. In the Wisconsin Catholic Charities case, now being considered in the Supreme Court, the issues include a focus on church-state entanglement. This review shows that the court opinion in Kennedy versus Bremerton School District engaged in considerable overstatement about repudiation of the norms underlying the Lemon Test. As highlighted in the Ten Commandments litigation, constitutional concerns of secular purpose and primary religious effect also remain in force. These norms did not originate in Lemon. Their most prominent place of origin is pre-Lemon in Abington School District versus Shemp, which struck down state-sponsored practices of daily Bible reading and recitation of a Christian prayer in public schools. In Roque versus Brumley, Judge de Gravel concluded quite correctly that Stone v. Graham remains good law. District court should not anticipate that the Supreme Court might ultimately overturn that decision, which rests on a requirement of secular purpose. Prodded by an earlier Fifth Circuit decision about judge-led prayer in courtrooms, Judge de Gravel took seriously the notion that historical practices should illuminate Establishment Clause questions. But he lacked a solid grounding for applying that idea. That was no surprise, because the Supreme Court has provided precious little guidance about how historical practices can be translated into standards for adjudication. Such practices cannot provide an adequate platform for decision-making without a normative account of the Establishment Clause to provide coherent boundaries on reasoning by analogy. For example, does a history of presidential Thanksgiving proclamations provide grounds to uphold school-sponsored prayer? Nor has the court explained how the vintage of such practices matter. Why should practices that developed in the 1820s, for example, be any guide to the original meaning of the First Amendment? Why should practices that date to the 1920s, like the use of a Latin cross as a generic war memorial, carry any weight in the assessment of what the Establishment Clause meant in 1791 or 1868? As we explain in our paper, historical practices should play a very limited role in Establishment Clause adjudication. The first question in any Establishment Clause lawsuit should be whether the claimant has stated a prima facie case that the government has unconstitutionally promoted or sponsored religion. Such a case will inevitably turn on the normative meaning of the clause, including the Madisonian idea that religion should be self-supporting so that it remains always in private hands. If the claimants can make out such a case, then the burden should shift to the state to show the challenged policy is supported by a set of historical practices like legislative prayer, sufficiently analogous and long-standing to overcome the bona fides of the Establishment Clause argument. The Louisiana plaintiffs presented a very strong prima facie case. The state is demanding the permanent posting of a sacred religious text, in this case, the Protestant version of the Ten Commandments. The state has no jurisdiction over the education of students in the content of sacred texts from any faith. Offered without comment, their theological thrust is inescapable. It was impossible for Louisiana to validate this display requirement by a showing from history. As documented in the expert report by Professor Stephen Green, American history reveals nothing close to a long-standing practice of constant exposure of the Ten Commandments to public school students. Aside from questions of purpose or history, the Louisiana law demands attention to whether the challenged practice produces a primary religious effect. The displays will reinforce the message of the commandments and increase the likelihood that students will internalize that message. Having these posters on the walls of every classroom, on every school day, in every grade from kindergarten through 12th and beyond, in a size chosen to ensure their readability, represents state-sponsored indoctrination in their sacred message. As the students change grades or change rooms, the images around the commandments may change. Mike Johnson today, John Marshall, or William McGuffey tomorrow. What will never change is the text of the Ten Commandments, as you saw it in our opening slide. No opt-out or escape is possible from that daily message. That kind of repetitive indoctrination by the state in a sacred text violates the Establishment Clause. We welcome your questions.
Thank you so much, and thank you to all our panelists. We're going to transition to the Q&A section now. So if you're in the audience, please use the comments, the chat feature if you want to enter your questions, and I can read them out loud. And while you're thinking of the questions, I want to begin by turning back to the panelists and asking them whether they have any questions or responses to one another's fantastic papers.
Luke, could I just quickly for Chip and Bob, I think they're really right to remind us that the no entanglement part of Lemon is alive and well in the court's doctrine still, and so Kennedy doesn't change that. But I wonder if you guys disagree with me. My impression is that the way Lemon's advancing religion prong was operated in the 70s and 80s, the way they operationalized this effects part of the test, that also has disappeared with the school voucher cases and others. That, you know, the way the court invalidated programs because it thought the downstream effect of the program was to provide some advantage or some assistance or some help either to parents or parochial schools. That seems to have gone away, so long as the criteria are neutral. Do you disagree with that?
Rick, I do disagree, because I think that the Supreme Court's decisions on the voucher cases and other things really try to maintain a distinction between the idea of the state promoting something and the state leaving open to the private choice of citizens the opportunity to engage in something. So I do think it's different. And so I do think that we're talking specifically about Mitchell versus Helms, right? And the continuing viability of the O'Connor concurrence, which I know seems completely antiquated, but really is the core question. You talked about it in the terms of differentiation, and I'm happy to use that term instead of separation, but but we're still talking about the boundary of the state's engagement with religion and the extent to which the state itself is fairly attributable with responsibility for religious indoctrination. And that question seems to me still alive. That in the voucher cases, we know that the state's not fairly attributable with, or at least we think the state's not fairly attributed with responsibility for such indoctrination because parents have the choice about where to send their kids, and public schools remain, of course, an option as well, but they also have a choice of non-public, non-religious schools. So I'm not so sure that the effects prong has gone away because I do think that there still should be a concern about the extent to which the state is engaged in promoting or sponsoring religious activity because that's not its job. And this goes to something that I think Angela dealt with very, very nicely in the idea of a liberal society. And this is why I think in order to understand your concept of secularity, it needs to be brought closer to the ground in order to understand how it works, which is why it would be good to hear you talk about the three pending cases and especially the Oklahoma Charter and the Wisconsin Catholic Charities case. But the idea of state promotion of religion as an effect of an activity seems to be still important, partly because of the judicial skepticism about measuring purposes. If we're really skeptical of the ability to get behind a legislature's purposes, then if we look at what they're doing, right, was the Louisiana legislature primarily motivated by concern about history, even though it relied on sort of some false statements about what Madison allegedly said about the Ten Commandments? So I'm going to stop there, but I do think that the idea of promotion remains important as a boundary that really comes into your concept of differentiation.
Can I just say really quickly, Luke, Bob, I agree with you if we're talking about promotion, and not to belabor the point, but I do think that some of the cases in the 70s and 80s took the effects prong beyond promotion and instead just looked at downstream effects, whether or not it was the intent to promote. But I think I agree with you that my idea of differentiation suggests a line like the one you suggest about whether the promotion is actually attributable to the state purpose. But sorry, Luke.
No, that's fine. Are there any other comments, or are we ready to go to the live audience?
I'd like to ask
Go ahead.
actually everyone about their thoughts on the the cases that are before the court right now, because we haven't had an opportunity, because there are three cases. And so I'd love to hear what I was thinking, in particular, Rick's secularity with respect to the Wisconsin case, the interpretation of the exemption that does not include Catholic charities, but does include, let's say, a Catholic diocese. So, is it an issue of the diocese is religious and the outreach activities of a church are secular, and is that the problem? And so I just thought of that case, but also, as Bob mentioned, to hear about Drummond as well. So maybe just passing it on to Rick and then back to Chip and Bob.
I'm happy to wait for Chip. I've already talked, and then I can.
Well, you know what? Let me say a little bit. I'm going to leave the Wisconsin charities to Bob, because you've been much more involved in it than I have. Drummond is about the charter Oklahoma decision to charter a religious school, and this presses exactly on the question that Rick and Bob were talking about. Rick was talking about downstream effects of certain kinds of aids that might go to religious schools that might help them pay for various health measures or testing or preparation of tests, things that are a little bit removed from religious education, qua religious education. But, giving a charter to a school in Oklahoma, or in most states, giving a charter to a school, 100% state financing, go and educate them the way you want, including in matters of religion. Now we're not talking about downstream effects. Now we're talking about the state being a financial sponsor at 100% of all the education in the school, not just math and science or history and English, but theology and religion and all the lessons associated with that. So those are certainly effects of advancing religious belief. And that's different from any of those cases in the 70s or 80s. And Drummond is going to test that acutely.
So I think, as everybody on this panel knows, I'm kind of involved in the Drummond case, so you can discount my views for if you want to. But I think the facts are different than you described, Chip. In my view, given the particulars of the way Oklahoma's charter school regime is set up, it's really no different than a voucher case. So it would be a mistake to think, in my opinion, that what's being argued in the Drummond case is that the state should be able to operate Catholic schools. I think we all agree that the state should not be allowed to operate Catholic schools. In Oklahoma, the charter mechanism is really just a matter of contracting. And so the result, whether it's some kind of for-profit or some kind of nonprofit or whatever, the participation is open for all kinds of providers to provide education. And I think that once one frames it that way, then Carson v. Macon in those cases kind of compel the conclusion that you can't exclude St. Isidore from the program when it's otherwise eligible. Again, I would agree with you, Chip, that if it was a state-run Catholic school, that would be unconstitutional. I think this is really just more like a voucher case. One of the three cases is this interesting one out of called Mahmoud versus Taylor out of Maryland, if I recall correctly. It has to do with opt-outs from some curricular materials having to do with sexuality and gender and so on. What I think is really interesting about this case is it's kind of a revisiting of this case from the Sixth Circuit like 40 years ago that we all teach but never went to the Supreme Court, called Mozart. And it raises what I think is a fascinating question about whether it counts as a burden on religious exercise if your kids are exposed to curricula that goes against your religion. And I mean, we're not even talking about whether the plaintiff should win. It's just whether does it even count as a burden. I think that it should count as a burden. What follows from that, I think, is kind of an open question, but that's kind of one that I'm following pretty closely.
I'd like to say a little bit about that one.
Go ahead, Chip.
Yeah, is that okay? Or unless Angela wants to chime in before I do that.
No, go ahead.
Okay. I live in Montgomery County. My children went to the Montgomery County Public Schools, right? So I feel kind of close, and I've written about this case, Mahmoud against Taylor. And I think Rick didn't state it quite right about what the materials are. This is not instruction. This is grades K through 5. It's not health education. It's not instruction in sexuality. It's not teaching people how to use a condom or how to not get pregnant. It's readings that include diverse characters. So there's going to be books with characters of color and characters of different nationalities, but there are also some readings appropriate otherwise to grades K through 5 that are going to have, a prince who falls in love with another prince, or a puppy who chases a pride parade. So there are things that touch on family life and relationships, but not on sexuality per se. And I think, let me go right to the question that Rick kind of skirted around a little bit, which is not simply whether this impose a burden on parents who don't want their children exposed to this. That's an arguable proposition, and it's going to be argued seriously in the Supreme Court. But even if you answer that question in the affirmative, there is a question of the impact on the school system and its program if you allow opt-outs for readings that are of a matter of considerable concern, but not so much concern that a majority in the community would get rid of them, right? If the majority in the community would get rid of them, they wouldn't be there in the first place. This is a minority in the community, but it might be a significant minority. And if we let them opt their children out of certain readings, there has to be a program of notice, which readings count. Something has to happen to those children when they go out in the hall. Somebody else has to supervise them. There has to be alternative readings. There could be a considerable impact on the reading program, on the curricular program, if you allow these opt-outs. And the pressure from that might be significant enough to end the diversity reading program altogether because of the difficulty of accommodating the numbers of students that are involved, maybe more in some schools than others. So what looks like an opt-out might wind up operating as a veto over the whole program. And I think this question is lurking in that case.
Go ahead, Angela.
Yeah, I'm wondering about something a little bit different, but it's related actually to more to the it goes to this issue of what some authors have called educational pluralism, and it's basically a view to having all education private but publicly funded. And so, it's we now have a public school system, obviously, and then we have the alternative, and we're, talking with respect to Carson and Espinoza about those alternatives. And also kind of in the background of Mahmoud, well, if you don't like it here in the public school, you have the option. And now maybe you even have some government assistance to lessen the financial burden. But some of the literature that I've seen in this, again, it's sort of really out of the box. But I mean, given the last month, there's a lot of unprecedented things happening. So just kind of how would you, Chip and Bob, think in terms of if there were no public schools and there were only private schools, could the state directly fund all of them, religious and non-religious, as long as they fulfilled, basic safety, et cetera?
Sorry to interrupt.
Yeah, go ahead, Luke.
Yeah, this is a great conversation. I feel bad interrupting. I want to make sure that some of the questions in the chat also get in. There's two questions for Angela. One is from Professor Thomas Berg. He says, I very much agree with your analysis and conclusion, but some of the SCOTUS decisions that you mentioned protecting Catholic institutions showing that liberal democracy responds would never have happened if President Hillary Clinton appointed justices, and perhaps not if Mitch McConnell had played hardball in 2016. Many traditional Catholics thought they had to go with Trump to avoid serious restrictions. As you rightly note, history tells us that people can think they're simply protecting freedom and so bring on an authoritarian. But how do you factor this in, the threat that religious conservatives perceived from liberal/progressivism, which he adds was to some extent well-founded, including the fact that Democratic appointed justices wouldn't have issued many of the decisions that you say are reassuring. And then just for reasons of time, there's another question for Angela. This is from Professor Kathleen Brady. With respect to the founding era, can it be mined for philosophical, even theological resources to engage the fundamental assumptions and aspirations of Catholic integralism?
Yeah, Tom, that's a great question, and it's sort of looming. If I were writing this 15 years ago, it might, or 20 years ago, I might have a very different take on it, and I'm much more critical of liberalism. But I think that that's part of our system. The framework, the rules we play by, have been robust. They've been challenged more recently, and religion has done well, with those challenges. Religious organizations, I should say, in terms of free exercise now being so primary and to what I think is a subordination of Establishment Clause, rather than a sort of tension between those two, or a co-equal understanding of them. And I think the establishment, that's why I suggested a more robust Establishment Clause to put limits on the free exercise interpretation. I guess my only answer is that we've still been functioning within liberal democracy, that parties, conservative, liberal, people vote with their feet and in the ballot box and all that. And so I think we had some, at least what appeared to be healthy changes. But so I guess it's not a very good answer, but that's the best I can do right now. As to Kathleen's question, I'm not sure. I mean, the aspirations of Catholic integralism to have a culture, a Catholic culture, or a cohesive religious culture, I don't think it's possible in the United States. The founders may have, I don't know. It's hard to know what exactly the experience of the different colonies and new states actually were. Whether it felt like it was religiously saturated, it doesn't, or whether it was a much more, well, it was a different time, and it's just hard to know how they would have thought about sort of religion in the sort of environment being a religious one, like I think the integralists would hope to establish. So I'm not sure that there's I'm not sure about the resources. That's beyond my skill set for deciding or being able to determine that what the founders or the founding period was like.
Luke, could I step in?
Yeah,
If that's okay.
let me there's two questions on opting in and opting out, and then I can throw it to you and you can respond to whatever you want to. So one is from Professor Barkley. Doesn't the fact that every other state in the country allows opt-outs from these sorts of programs indicate that it's not so unmanageable to administer? Another one from Stephanie Athanas. Why is it an opt-out instead of an opt-in for parents who want that type of reading? Why is it the default and not an optional addition? So I'll just put that on the table and give it to you, Bob.
I want to sort of go back to some of the previous questions, because the opt-in, opt-out things, I mean, Chip can certainly handle them, but I do think that if we're going to talk about the more sort of fundamental aspects of this, first, in terms of history, that I think it's important for people to recognize in historical terms the incredible difference between the 1780s and 1790s compared to the 1820s and 1830s, and the amazing transformation of American society that the Second Great Awakening caused, and other forms of what are Protestant revivalism, but in the idea of recreating what had previously been a Puritan image of a Christian America. And that's not nearly as present in the 1780s and 90s as it is by the 1820s and 1830s. That's the first thing. Second thing is that and this goes a bit to the Wisconsin Charities case this term, that accommodation has to have some ability to be bounded. And that's really what's at issue in the Wisconsin case. The Wisconsin Supreme Court's decision is a mess. I mean, Rick said hot mess. It is a boiling cauldron mess. The opinion is useless, but the result reached seems to me correct, that the state can distinguish when it grants an accommodation between different kinds of activities that people may themselves consider religious. So when the state uses the term religion in an accommodation, the state has to be able to define the boundaries of that accommodation. Otherwise, we get into just the incredible problems of unmanageability that led Justices Coney Barrett and Kavanaugh not to join Alito in Fulton versus the city of Philadelphia, which I think is really important, that they saw that overruling Smith as a general matter was going to make things untenable because we do not have a boundary. And that, I think, is also at issue in Wisconsin.
You want to let me answer the opt-in, opt-out question, or are we done?
No, go ahead, and then we'll be done. Yeah, thanks so much.
I'll be quick. The reference to opt-outs that other states allow involves sex education in middle school and more typically in high school. And states, including Maryland, do allow opt-outs. Usually they require the parents to show there's going to be some alternative education about HIV/AIDS and about pregnancy. But those are limited to older kids who are really getting sex education. The Montgomery County program at issue in this case is kindergarten through 5th grade. It's not how to do it, sex education. It's about diversity of people in the community, including LGBT people. So the comparison to other programs for older kids doesn't quite fit. And why can't people simply decide to opt in? The answer is that the county has decided by its political process that there should be lessons in diversity that every student should learn, not the ones whose parents decide to drop them into it, but that everybody in grades K through 5 should learn about race, about religion, about sexual orientation, etc. There are lessons for everybody. The parents are not obliged to agree with the underlying moral principles that might be connected by some to those lessons, but they're required to have their children in the lessons, and that's what the case is about.
Well, with that, I want to thank everyone again, especially our panelists, the Law Review, for this really wonderful and provocative session. And I want to encourage everyone.